Thank you. Well, good afternoon, everybody. I'm thrilled to be here because I think this is an important topic. Cybercrime or crime is a topic that I think confuses a lot of people because it involves elements of cyber or computers as well as traditional crime issues. And particularly in an insurance standpoint, there's a line of insurance known as cyber liability or referred to as cyber liability. And there's a line of insurance referred to as crime. And I think the gaps between these two lines of business confuse a lot of people and create a lot of interesting scenarios. What we'd like to do for you this afternoon is to start off, we'd like to talk about some of the types of cybercrime that we're seeing out there in order to set the stage and give us a basis to discuss the topic in some more detail. So with that, let's move on to the next slide. I think I did that correctly. There we go. And let's talk about some actual types of cybercrime that are occurring out there. The first slide is compromised banking credentials. And Juliet, you being a crime underwriter, I think you've had a lot of experience with this type of scenario. Could you walk us through what a compromised banking credential situation might look like?
Sure. So what we've actually been seeing a lot on the fidelity side in terms of cybercrime is more an attack on the bank's customers than the banks themselves. So banks receive any number of threats every day, and they've gotten rather adept at dealing with the frontal issues of, denial of service attacks and sort of the traditional, I'm the hacker and I'm coming at you from the front end bank. But what we've been seeing more of is an attack on the bank's customers because the majority of the bank's customers don't have the resources necessary to have the proper security controls in place. And so what we've seen happen is that a bank's customer will have their credentials accessed, whether it's hacking into their computer system, hacking into their email, and then with those credentials or with that information, they've been able to log on to the online banking platform or send an email to their financial institution requesting any number of things: change of address, change of phone number, change of email address when you get a kickback saying, is this you? So what we've been seeing is more of the funds transfer requests coming from those individuals purporting to be the bank's customers, and it's really put an onus on the banks to do more in the way of monitoring how they're authenticating these requests. I would say that there is a decent amount of spearfishing going on in terms of trying to get a customer to click on a link in an email that looks like it's definitely from their bank, but the majority of issues that we're seeing, again, are on the customer side.
I'm gonna interject for a second because it appears we're having a problem with these slides. So I'm going to ask one of our administrators if they might be able to help advance the slide for us there. Okay, I think it's coming.
Nick,
Juliet?
Nick, if you pardon this interruption, several of these slides have animations, so you'll need to continue to click the next button to push through all the animations.
Oh, okay. Juliet, what sizes of losses are we seeing with compromised banking credentials?
I would say the majority. Sorry.
What we're seeing there?
I would say the majority of losses that we've seen have been in the community bank space because a lot of their customers are those smaller mom and pop shops. And anywhere from $250,000 to $500,000. We've, of course, seen some larger ones, but those are more a result on the commercial side and hackers going directly after a commercial entity rather than directly after the bank. So, but I would say, definitely under $1 million per incident, but rather frequent attempts.
Okay. So, because compromised banking credentials certainly sounds like a significant problem. And let's talk about a slightly different scenario, fraudulent instruction, which I like to call kind of email spoofing or maybe even a type of spear phishing. Juliet, have you seen anything happen along here, and can you give us a description of what commonly happens?
Sure, yeah. We've seen a lot of email spoofing, and we've actually even seen some incidents of phone spear phishing. So I might be a bad guy, for lack of a better term, and would identify an organization that I want to go after, and I would call that organization's finance department and pretend that I was the CEO of the company or the chief financial officer and say, I've had, we're trying to close this transaction. It's highly confidential. I'm going to send you through some wire instructions. You can't tell anyone else about this because it's so confidential. And we've even seen incidents where employees have forged their managers' signatures, sort of pushed through and around any control measures that organizations have in place to transfer funds. We've also seen incidents where an individual's email has been hacked and requests will be sent to their financial advisors to execute trades or to transfer funds to different bank accounts, or they'll say, I'm out of the country, I need $100,000, please transfer this. And again, in the community bank space, we've seen more frequency in terms of success, but I think that the banks are getting better at recognizing that this is probably not the best way to do business, to accept an email for a funds transfer request. But those are the types of things that we're seeing more frequently.
No, a lot of times it seems to be that somebody pretends to be, as you said, an employee and or as a key employee, like an executive, and sends an email to an employee at the organization. What types of sizes of claims are we seeing here? How significant are these?
We've seen, the market's seen anything ranging from, like I said before, $500,000 to, millions of dollars, and that's obviously incremental transfers. But what we've seen is that not only are these bad guys getting more adept at knowing who to target, they're also a bit more cunning in where they go. So they'll call a foreign subsidiary and they will maybe target an employee who wouldn't be as familiar with who the chief financial officer is, or maybe they're not that familiar with the funds transfer procedures, and that is where the larger pops have been. $10 million has been one claim on a large account that's based in the U.S. that had a foreign subsidiary issue. So it's definitely prevalent, but hopefully the larger ones are not too prevalent.
And again, this really isn't a new type of crime, but it's just sort of incidentally using a computer, isn't it?
Yeah, this is not anything new, but it's definitely being perpetrated in a different way. So from an insurance perspective, we've had to sort of adapt our approach and what we're really trying to pick up and update language and update terminology, as well as educate our insureds and our brokers on what they really should be looking for and what we're trying to do to remediate any of these sort of gaps.
Okay. Let's move on and talk about stolen payment card information. Now, stolen payment card information is a little bit of a different thing, but the kind of thing that I think we're hearing about a lot in the news. Matt, can you give us some examples of stolen payment card information and how that happens?
Yeah, so there's various ways that the malicious guys are getting a hold of payment card information, and that could be a debit card, an ATM card, or a credit card, and they don't really care what kind of card they get, and they just try to get as much as they can. So of late, we've all seen the news about Target and Home Depot and some other large retailers that may have been compromised. I mean, they're very large compromises that occurred over the last year or so. There's also these very small ones also, where they may either infiltrate a bank or a merchant, or as Juliet said, maybe just an individual's PC or laptop. So it just, there's various ways that they're getting that data, and a lot of times the people who are stealing the data aren't really using the data, they're selling it themselves on black markets, whatever. So the more credit cards they get, the more they can sell.
Great, thank you. Now, Matt, when people hack into these computer systems, how are they doing that? What types of hacks are we seeing? Can you give us some specific examples of how these things work?
Yeah, so when they talk about a large corporation, they're trying to get into, well, there's a couple options. So one is the large enterprises where they, break into a retailer and they actually start infiltrating the point of sale equipment, which is which have the major breaches have occurred. But they're probably more few and far between. The other way of getting this data is people using on their own PCs when you're buying on Amazon or using your credit card via internet banking. So they may try going after individual PCs, as we talk about phishing, and we'll talk about spearfishing a little bit also. The other thing that's becoming more and more prevalent is card skimming, where criminals are actually building little small devices that sit on top of a kiosk, a credit card kiosk or an ATM machine that blends right in. And those devices actually have the ability to grab the swipe card data. Sometimes they have little cameras nearby and actually watch people enter their PIN. And then they send off via either stored or sent off via Bluetooth. So there's again, the criminal minds are, it's very advanced sometimes, and they have these, strange ways of kind of getting their data as best they can. So on those, kiosk type things, you always kind of want to make sure it's a solid piece of equipment on top where you put your credit card in.
Good advice. I think one of the things that's misunderstood about credit cards is that this is really a business issue. It's not really a consumer issue. The consumer really is held harmless from any sort of theft of credit card information, in that the banks don't hold them accountable for card not present transactions or transactions that they otherwise didn't commit. Rather, the cost of fraud and cost of reissuance for the cards is passed back to the merchant through the payment card information, the payment card industry system, which sends the assessments back against the merchant that is responsible for the loss of these card numbers to compensate the issuing banks for their losses. Now, I noticed that we had a comment here that Chase Bank was also involved in a credit card hacking event. And I know Chase Bank was, according to recent press reports at least, because I only know what's been in the press, was the victim of some type of computer hacking. I don't know that any sort of card information was actually stolen from them. The examples that I would give where we've seen card information stolen are more on the retail end, and most recently Home Depot, and before that Target, would be very good examples of the type of thing that we're seeing there. If we can move along to the next slide, let's talk a little bit about phishing and spearfishing. Matt, could you walk us through phishing and spearfishing?
Sure. So we've all seen these emails before where it's a fictitious email that's trying to entice us to do something and click on a link. Typically they've been from financial institutions saying, there's a problem with your account, click on this link, log in, and we'll fix your problem for you. Typically it's fake because you may get an email from Bank of America saying your account has a problem and you're not even a Bank of America customer. So those phishing attempts tend to be very broad, and the criminal entities just get loads and loads of email addresses, and they just start, sending out their emails with links to malware and other types of malicious links. Typically, they don't last very long because eventually they send it to someone who, whether Bank of America gets a hold of it in my example, and they reach out and actually bring down that link to prevent the spread of malicious activity. Spearfishing is it's a phishing attempt, but very pointed and very targeted. It's a very targeted attempt. A very classic one is you get an email saying that, hey, you know, an executive gets an email, and they just presented at a conference recently. So they said, I videotaped your presentation at a conference. You were great. You know, here's a copy of the link. That link may have malicious email in it or a malicious attachment in it. The executive normally gets it and says, wow, let me see how I looked. Clicked on the link, and now his PC is infected. So they're going after an executive, very targeted, and they'll probably get more. If they infect him, they have, you know, more benefit from them, and they gain a lot more.
All right, thank you. We've got a couple questions here that I think would be helpful to address at this point. The first question is, if your bank account is hacked into, is the bank responsible for reimbursing you? And I think that that's kind of a complicated answer because I think it depends on how your bank account was hacked into. Julia, could you help explain that?
So the banking, regulations under Regulation E, it actually is rather clear on the bank's liability to their retail customers, meaning your personal bank account, my personal bank account. If your account, your personal bank account, you lose your credentials, is hacked into, and all of the funds are drained out of your account, the bank is in fact liable to put that money back into your account. The conditions are a bit different for a commercial entity like a bakery. So if a bad guy hacks into the bakery's computer systems and gets the logon credentials for the treasurer's account and then logs onto the bank and transfers funds out, the liability that the bank has to that commercial entity is a little bit more of a gray area. There's been some case law that has said, yes, bank, you are liable for this unless you provide your commercial clients with enough control authentication measures to prevent something like this from happening. So what I mean by that is, do you provide your commercial customers with an RSA token? How are you, how can you log on? Is it just a username and a password? Is there an image verification? Is there a callback number? So things like that. The onus is really falling on the banks to make sure that they're providing enough security measures to protect their commercial clients. So I think it's still a developing area, but for a personal account, if your account is hacked into and drained, the bank is liable to make you whole for that money.
Unless you're responsible for giving up the credentials, correct?
Right, unless you hand out, your PIN on the street to someone, which I wouldn't recommend doing, but yes.
Well, you said it was kind of a gray area, but, if somebody was able to get your banking credentials through, say, a spearfishing attack and then go to the bank, there would be a good chance that the bank would not be liable for reimbursing you in that case, if I understood what you said correctly.
I believe so, but I would go back and look at the banking agreement because a lot of times the banks, do push that back off onto the consumer. Okay.
Got another question here. Does an issuing bank still accept liability for reimbursing fraudulent transactions if the card data was divulged by the cardholder as a result of a phishing scheme? To be honest, I don't know the answer to that question, but I believe that in that case the consumer would not be liable for the transaction, and the reason is because it would be a card not present transaction that would take place, and consumers are not liable for card not present transactions. From my understanding, the retailer takes the full risk of any sort of fraudulent transaction in a card not present transaction. Matt, Juliet, Thaddeus, do you guys have any thoughts on that? Okay, not hearing any.
No, I don't know.
I'm sorry. That's okay.
I have a couple thoughts.
Okay.
Just from a credit card perspective, a consumer has a window in which to report any fraudulent charges, and generally it's 60 days. So if you are not monitoring your credit card and they're running up charges and you don't get your bill and you don't notice it, which I would assume is highly unlikely in today's day and age, because every time I look at my email, I have, 4 different emails from Chase or Citi or whomever saying, you owe us money on your credit card bill. So I think the likelihood of not knowing within that window in which you have time to report is minimal. But if you fail to report in that 60 days, I think that there is a chance that you could be liable for some of those charges. Again, you have to go back and look at your individual agreements for each of your cards or your banking agreements to kind of, bring that full circle. But that's generally my understanding of the process.
Yeah, that's a great point, Juliet. Thank you for bringing that up. Matt, I think we have a question for you on spearfishing. And they're asking if can malware be placed on one's computer simply by replying to the malicious sender's email? I think you're our technical expert here. Could you try to address that for us?
No, typically not by replying to an email. Typically it does take an active thing of clicking on a link, potentially reading an email if depending on how your browser is set up or your email client is set up. But if the question is more about replying to an email, I would never reply to a malicious sender's email. But first of all, give them the information that you actually do exist and that you read your email. So I would definitely not respond to emails. If you don't know who it's from and it looks kind of, undesirable, I would just immediately just delete it.
Okay, great. Thank you. I want to take 2 more quick questions, and then we'll move on to the next portion of the presentation. But we have a question here. Will you reduce your risk of credit card information being stolen by not using your PIN when making transactions? And I think that's a good question because I think there's some confusion in this area. I'm going to throw out my answer, and then I'll let the panel chime in if they wish. I don't think you reduce your risk in that case because the credit card information is still going across the system. I do think you raise the risk a little bit of your PIN actually being stolen, but I would actually recommend to people that they try to avoid using a debit card. And I think this really is a debit card question rather than a credit card question. I would suggest that you avoid using your debit card to make retail purchases, because even though when you're using your PIN, because the problem is with your debit card, if the money is taken out of your account fraudulently due to fraudulent transactions, you may have an increased burden of demonstrating that to the bank before they reimburse the money into your account. Unlike a credit card where you can dispute that charge before you pay the bill. So just as my own personal advice, I would avoid using a debit card to make purchases and simply use I use my debit card strictly as an ATM card and use credit cards when making purchases. Anybody else in the panel have a comment on that?
It's sound advice. I agree.
Okay. One more question for the panel. Is there a trend toward completing transactions by completing transactions by mobile devices going to present more, less, or just different risk? Do you guys have any thoughts there?
This is Matt. I think there are different risks. I think as more things move to mobile, there's more malware that starts showing up on mobile devices now. More on Androids than on iPhones, just due to the way the technology has been put together. But I think, as things move off to other payment types, I think, the criminal activity is going to look for other ways, to infiltrate that method. So mobile phones aren't necessarily, much better right now, and much better long term. Right now they may be, but Androids, there's a lot of malware out there. So.
Okay. Well, at this point, I'm going to move it to the next section of the presentation, and I'm going to ask Thaddeus to speak to us a little bit about some legal issues.
Okay. Well, thank you for having me. So I just want to start off with a few caveats. Unfortunately, or fortunately, depending on how you look at it, the Supreme Court hasn't had the chance to look at things like spearfishing and phishing. They have provided us with some groundwork with respect to the use of technology by the police, and also the ability of police to access your technology. So that's kind of what my presentation is going to be out. I'm going to be speaking in the kind of the broad context and looking at some Supreme Court cases where these issues have been raised. And I'm going to hit all the points there that are provided in the seminar, but I'm going to break it up a little differently. I'm going to start off by looking at the Fourth Amendment, and then I'm going to move to the Fifth Amendment. And so basically, I think we're all familiar with what the Fourth Amendment is about. There it is in the italics. You can see it from the Constitution. And when looking at the Fourth Amendment, I'm going to take a look at initially a few cases where the court has struck down the use of technology by police with respect to investigations. And then I'm going to look at the limits the court has placed on law enforcement with respect to accessing technology. And for the Fifth Amendment, we're going to look at a few cases with respect to, what are the requirements when law enforcement attempts to require individuals to provide their passwords. And again, this primarily arises with respect to encrypted files and requesting information of that nature. Okay, the first case I think some of you are familiar with is Kyllo. All right, Kyllo is, at least with respect to technology, a somewhat older case. It was decided in 2001, and it involved thermal imaging. So here, law enforcement believes that Mr. Kyllo, this is up in Oregon, is growing marijuana at his residence. All right. So in order to get a search warrant, they want to get sufficient information for a search warrant that requires probable cause. They use, a thermal imaging device, and they point it at Mr. Kyllo's residence. And with this thermal imaging device, they're able to determine the amount of heat radiating from his home. So they use this information. They determine that more heat is coming from this person's home than anyone else on the block, and it's a lot more heat coming from this person's home. This device allows police to tell that the heat is coming from specific areas in the house. They see it's coming from the roof and from the sidewalls of the garage. So they use this information coupled with the electric bill from Kyllo's house. They use it as support for probable cause, probable cause that you have information that if discovered will lead to evidence of a crime. They present this information to a magistrate. Magistrate issues the search warrant, and lo and behold, they go in Mr. Kyllo's house and they find 100 marijuana plants. So he sees this, he does a conditional plea, and he challenges the constitutionality of the police conduct. All right. So the issue here is whether or not the thermal imaging device violated Kyllo's Fourth Amendment rights. Did what the police activity, what happened here, did it go beyond the parameters of what's allowed with respect to police conduct? Now, this was a very close case. All right, Justice Scalia wrote the majority opinion, and it was decided 5-4. Now, the rationale here for this case was that this device allowed police access to the interior of Kyllo's home, and another big point was that this technology, and at the time in 2001, and I would say even today, was not one of general public use. So that was sort of the rationale of what the Supreme Court used to decide this case. So now we fast forward today. So what we may ask, what does Kyllo, what does that have to do today with law enforcement practices? Well, one question that arises is that how will this work with respect to, say, the cloud? All right. I mean, what restrictions, because these cases haven't risen up to the Supreme Court yet, so we have to look at Kyllo for guidance. What restrictions are going to be placed on law enforcement with respect to doing searches online? And so that's the major question. I think you look at Kyllo, and I think people will look to this case to see how far can law enforcement go if they want to do these type of searches on someone's personal cloud. And these questions are important, obviously for the reasons stated earlier, but that's where the criminals have moved to. Before, a lot of the crimes happened offline, but now the criminal activity is moving online. So the police are following the criminals online. But the structures really aren't in place in many cases to guide the law enforcement to how far they can go and what can they do. So we're looking at things like Kyllo to see, what restrictions can be placed on law enforcement with respect to searching and seizing property online. Another issue left open by Kyllo was whether or not this rule is going to change if this technology becomes more common. I don't think thermal imaging is there yet, but we can look at other things, other things that have become quite common. For example, in 2001, the smartphone wasn't that common, but now today it's almost ubiquitous. So is that going to change some of the analysis that the Supreme Court relied on in a case like Kyllo? So those are the endearing questions that's left by this case. And one thing, at least in my segment of the presentation, I want to kind of reiterate, or at least throw out initially, is the challenge that the court has with respect to, understanding technology and applying technology. Because in many of the things that I'm going to talk about, they can still occur without the use of technology. So, for example, I talk about, we're looking at the heat emanate from this guy's house. In order to determine that, they use a thermal imaging device. Well, the police could just sit outside your house and wait for the snow to come and see which part melts faster. So that's constitutional. But yet, if they use a thermal imaging device, it's not. So it's kind of interesting to see the hiccups sometimes with respect to the application of technology. So here, the Supreme Court is uncomfortable with thermal imaging device, and next we'll see the challenges or the issues the Supreme Court has with GPS. But one of the underlying questions there is many of the things that the police are doing, they could still do with just human beings. It's just easier with technology. And so that's always the balance of how much are they going to allow law enforcement to use technology. So here they said no to thermal imaging devices, yet it remains an open question. Will this change? This wasn't a slam dunk case. It was it was a very close call. And will things change as things become more more used, more common in society? So that is Kyllo. Now, the next case I think more people may be familiar with, and that's United States v. Jones. Okay, this is the use of GPS. I think most people are familiar with the global positioning system, where you're able to track yourself, you can track other people. So in this case, police suspected that Antoine Jones was involved in drug trafficking. And in order to get a warrant to actually search his home, they decided they would track him to get information, because police are trying to get information so they can build up a case, and then they can eventually get a warrant or they can arrest the person. So here in United States v. Jones, the police placed a GPS tracking device on this man's car. Now, initially, they had a warrant to do that, but the warrant had expired, so it wasn't valid. This GPS tracking system that they had could track this car's movement 24 hours a day for 4 weeks. So they just had to punch in a number, and at any time of the day, they could find out where this vehicle was. So the question before the court was with respect to, is placing a GPS device on a suspect's car a search? All right, is this a search? Because if it is, he can argue that his Fourth Amendment rights are violated. The question, at least for the Supreme Court, was quite obvious. They said, yes, it's a search. This was a 9-0 decision. However, the court, again, they sometimes struggle with the application of technology, wasn't quite sure why it was a search. Some of them based it on a traditional concept of the trespass doctrine. You trespass on someone's house. Historically, when we thought about searches in this country, we searched, when the police searched things, they usually search the person or they searched your house. But, as we've advanced with technology, now there's other ways to conduct searches. So we kind of abandoned the trespass doctrine. It's always been valid, but we kind of let it moved on to sort of a expectation of privacy doctrine. Well, here the majority, and some people say they kind of punted on the issue because they didn't want to actually tackle the tough issue, said that the police violated the trespass doctrine, and therefore this was a search. Now, part of those in the majority, in a concurrent opinion, viewed it not as a trespass, but as an invasion of this man's privacy. All right, because he had a reasonable expectation of privacy. They viewed long-term GPS surveillance as an invasion of privacy. Of course, but that wasn't part of the majority opinion. And so the rationale for this case, the court said that this idea of placing GPS on someone's property was consistent with the common law concepts of trespass. Many people believe that the Jones decision left more questions than answers because they never really tackled the real issue of whether or not you can place GPS on somebody and track them. Now, again, I raise these questions so you can better see the challenges that face law enforcement when they attempt to find or track down or arrest the bad guys, because they have to, we have to maintain this balance in society to ensure that people's constitutional rights are protected. So the court here never really addressed the issue of whether or not the search was reasonable. And they saved that for a later day, which is going to be an important question because for law enforcement, GPS is a very important investigative tool. So you don't really know the answer to that question. You don't know with respect to whether or not police can use GPS absent a physical intrusion. So if you took away the trespass doctrine, for example, let's say they didn't place anything on this man's car. Let's say instead they tracked him by cell phone towers. Let's say they just used his smartphone. Whenever his smartphone was in his car, they were able to trace him through cell phone towers. Would that be allowable? And so they never really got to that issue with the court. The majority opinion never really got to that issue. And again, one of the questions that I find interesting, and you saw it earlier, is that it's constitutional for the police to do the same thing absent technology. For example, instead of using GPS, if they just had a stakeout and follow this man wherever he went on the public streets, that would be constitutional. But because they use the GPS system to do it, well, here they base it on trespass, but the other judges found an invasion of privacy, they found that unconstitutional. So it's this challenge of how the court is going to address the advancements with respect to technology and how it's used not only by the bad guys, but also by law enforcement. So these problems still need to be addressed with respect to the court. It seems to me, what I've seen lately is that there seems to be a pushback from the court. And I'm going to talk about another case in a minute to illustrate this, but there seems to be a pushback from the court with respect to giving individuals more privacy. All right. Now, I think it's sort of a pendulum that swings back and forth to the Supreme Court. But now it seems that the Supreme Court is very high on the pendulum of granting individuals more privacy, even at the cost, at the expense of law enforcement to do their job. So that's where the pendulum is now, and it may switch if you see crime rates go up, if you see more examples of fraud, of cyber attacks. The pendulum may swing, but right now it seems the Supreme Court is going more towards providing people more privacy rights. Okay.
Thaddeus, can I jump in with a question here?
Oh, sure. Uh-huh.
You mentioned law enforcement using our cell phones and our cell phones pinging the tower as being kind of an open question. And the question occurred to me, what about things like the Easy Pass or the toll, the things that we have in our cars that automatically pay tolls, which in the East Coast is known as Easy Pass? What about using Easy Pass records and things like that to track our movements? Is that something that's allowed, or do you have any thoughts there?
Oh, sure. Yeah, no, they can definitely do that. They can use your Easy Pass. They can do that. And I had a few years ago, I remember I was involved when I was in New Jersey clerking for a judge. That was one of the ways that law enforcement was able to track some bank robbers that were coming from New York City down to New Jersey to commit bank robbery. They admitted as evidence their Easy Pass because they had went through the tolls. They had tracked them from there, and they said yes. Now, that, generally speaking, is allowed. They would not prevent that. And so that raises an interesting question, though, is that then some would say, how is this then different? How is the GPS different then from London, where they have, I don't know, God knows how many cameras, and they photograph everything? You know, can they do that? And I think it comes down to, you know, here they punted on the issue of reasonable expectation of privacy, but it comes back to, as a society, would we believe that we have a reasonable expectation of privacy in not being followed by GPS 24 hours a day for 4 weeks? And is that a belief that society wants to uphold? If I'm making myself, I think many of the Supreme Court feel that, at least 4 people felt that way. Now, the others, they never came out and made a call on that. They didn't make a call on with respect to GPS monitoring for 24 hours a day for 4 weeks. 4 of them said, you know what, that violates your expectation of privacy. That's an invasion of privacy. So we would vote that down. But 5 did not. So that example is not clear. I would tell you the Easy Pass, that they would allow. They wouldn't be violating constitutional rights. Now, again, if they were to monitor you constantly by your smartphone, that may, I would think you'd run afoul you might run afoul based on U.S. v. Jones. You might, but the majority hasn't held that yet. So that's sort of an open question. With the Easy Pass scenario, I think he would be.
Okay. Well, along a similar lines, we just got a question. What about automobile information held by commercial third parties, like insurance companies? Clearly, that may be available to law enforcement by subpoena. Question?
Yeah. Internet. Okay. I think it would be okay. I think it depends. It depends how. I guess the question I would have then on that is, what information is being submitted? If it's just that you were in a crash, that a crash occurred, like the black box sort of thing, I think you have a stronger chance of getting that admitted. But if it was more of, I want to watch this person and track that person through that device, I think you might have an issue. But if it's just, I think if I'm making myself clear, it's like, I think most vehicles now have a black box. They may not call it a black box, but they have a device in the car. And if it's just for, there was an accident, we want to know what time you put on those brakes or how fast you were going, I think that's you have a stronger likelihood to get that submitted than if this constant 24-hour monitoring.
Okay, that makes sense.
I think that would be a bigger challenge. And again, you know, they're trying to, the Supreme Court is trying to, you know, find, you know, they're deciding what, as a society, would we have a reasonable expectation of privacy in, and would that be one of those examples? It might be, you know, it might be.
Well, I think you characterized it well, as the courts trying to balance the rights of individuals versus the need by society to keep criminal activity in check, and it being a balancing act. We got one more question. Let me throw out here that came in from the audience. The question is, I saw a recent article about a police department that used information from a criminal's phone, which the criminal willingly gave up, to set up a Facebook page, a fake Facebook page, pretending to be the criminal. Is this something that you've read about? And if yes, any thoughts?
Well, yeah, that's very interesting. So let me explain this. I'm going to give you some background. Okay, there's this woman in, I think, Watertown, New York. All right, so she was involved in drug trafficking. She was a minor player. All right, there's some major players. All right. She pled guilty and she cooperated with the government. Part of that, she said she would cooperate. When she was arrested, she turned over willingly her cell phone, her smartphone. Okay. She was a bit player. She basically got probation. Okay. There were some major players. One of the guys who was running the ring was her boyfriend. He got 16 years. So he's what they may call a big fish. Okay. So between her pleading guilty and her being sentenced, the government used her cell phone, created a fake Facebook page, which just so everyone knows, if you go to any of these Craigslist ads or any of these back page ads, every third ad is a law enforcement undercover. Just hope everyone knows that already, but that's law enforcement. Anyways, here, the government used a real person, which I didn't know they did. They used this woman's real picture, real name, and set up a Facebook page. And not only that, they used pictures from her cell phone on this Facebook page. And some of her pictures were kind of risque. I mean, you didn't know if she was in a bathing suit or a bra and underwear. And they also had pictures of her child and her niece. These are real people. Use their real names and set up a Facebook page, and then use the Facebook page to interact with suspects, criminal suspects, because they're trying to get them to make incriminating statements. They're trying to set up some kind of sting operation. Well, the woman found out about it only because her friends came to her and said, "Why are you probably shouldn't post those kind of pictures on Facebook." She goes, "What do you mean? I don't have a Facebook page." Well, yes, you do. And so apparently now there's this big hoopla, and there's an article today in today's Washington Post talking about now that DOJ is now going to review their policies on creating fake Facebook pages. Now, if you look at the terms of service on Facebook, you can't do that, what the government is doing. That's, of course, we know different rules apply, but that you have to be the person. You can't create fake Facebook pages like that. But this woman now has brought a civil action against the government, arguing that this violates her constitutional rights and the Federal Tort Claims Act. The government responds by saying, well, you consented to this because you gave us your phone and you agreed to help us. I don't know if that's consent. I think that's a stretch to say that just because I give you my phone, that means you can set up a fake Facebook page with my photos. I think they're going a little far on that. But that's right now in litigation, and they're getting a lot of flack because people don't really – I think people are surprised that the government would go that far. I knew they created fake Facebook pages all the time. I didn't know they created fake Facebook pages of real people. So they said DOJ, and today, at least the Washington Post has reported that the Department of Justice is going to review their policies with respect to creating social media accounts. But so that's in litigation. She's suing she's suing the Department of Justice right now for Federal Tort Claims Act violation, probably an invasion of privacy, and she says her constitutional rights were violated.
That's certainly an interesting case. We got another question along similar lines. So let me throw this out to you right now. With regard to usage-based insurance, the box installed into the car contains information about the speed and location. However, the user agreement with the insurance carrier defines how the information will be used for insurance rate discounts. If the police attempt to collect and use data outside of the insured's user agreement with the insurer, would that invade the person's privacy rights? Any comments on that from a law enforcement point of view?
Well, the thing is, just we can back up for a minute. The Bill of Rights protects you from the government violating your constitutional rights. It doesn't protect you from Thaddeus Hoffmeister violating your constitutional rights. It doesn't protect you from the insurance company violating your constitutional rights. So if the government gets information from somebody else and then uses that against you, you're not, criminally speaking, that's not going to stop them. You're not going to be able to suppress that information. As long as they're not working in cahoots with the government can go to other people and get information about you and use that to prosecute you. Now, you can sue people civilly. You can bring a civil action against somebody to challenge that. You can do, but generally speaking, in a constitutional criminal prosecution, generally you are challenging an illegality by the government against you, your interaction, not a third party. And so if they go and use that, information from that, and that's a violation of, I mean, I think you could bring in a civil action against them. And there may be, and I may not be aware, but there may be state laws that say you can't use this information. For example, we're going to talk about the Stored Communications Act. There's federal statutes that prevent the government from accessing your Facebook information. They have to follow a certain format to do that. They have to get a warrant in many cases to get your Facebook. So there may be statutes that I'm not aware of that are in place that limit how police can access that type of information.
So if absent any statutes, you wouldn't be able to suppress the evidence, but you certainly might have a civil claim against the insurer.
Yeah, I mean, if as long as they're acting independently and not at the bequest of the government, that's what I would think.
Okay. Well, that exhausts the immediate questions. So
okay.
Let me turn it back over to you to continue.
Okay. All right. So the Trojan Horse warrant. So the government has to get creative, or they have to keep pace with the bad guys. And so if people are someplace else using their computers to hack in to others, to commit crimes against others, to commit fraud, the government wants to go after those folks, and sometimes they don't do the traditional, raid the house. They go to the computer through malware, all right, and it's called the Trojan Horse warrant. There's not a lot of information about these warrants, all right. You won't find a lot of case law on them, but they do exist. This allows law enforcement to place spyware on an individual's computer and to record things, keystrokes, passwords, to find anything saved on your computer. All right, this is what the government can do. And so, again, there's not a lot of cases. There's maybe one or two cases that discuss the Trojan Horse warrant, but it's a warrant nonetheless. That means for any warrant, it has to be supported by probable cause. So the law enforcement has to go to the magistrate judge and fill out an affidavit, show a prima facie case that they will find evidence of a crime. All right, that's support of probable cause. They have to particularly describe the place to be searched and the things to be seized. They have to say, we're searching this computer, we're going to seize this information. A warrant has to be executed in a timely fashion. All right. Also, for something like a Trojan Horse warrant, many times it will require the government to disable or delete the program once the search is complete. Now, some of the problems that I've seen at least one kickback, and it was kicked back because they could not be specific enough about the computer they were going to search. And the court was concerned about the jurisdiction. Generally speaking, the court, if you're in federal court, like say you're in the federal district court of Southern District of Ohio, they've got to follow the limits of their jurisdiction. All right, and they couldn't be specific of where that computer was located. They also couldn't tell how this malware would not hamper other innocent computers. So that was another reason it got kicked back. And another issue that can cause problems for the government here is the antivirus software that people have. So what I've heard is they're trying to work some agreement out with some of these antivirus companies to allow the government to get a pathway through it, so they're not stopped by the antivirus software that we have on our computers. Those are the issues you see with Trojan Horse warrants. Now, again, you don't hear a lot about them. The government does have these. these types of warrants, they still have to meet the requirements of the Fourth Amendment. So they have to follow the requirements of all warrants. All warrants have specific requirements that must be met in order to be issued. This one, I would say the unique thing about this Trojan Horse warrant is that they have to have some language in there to say it's going to be able to disable or delete the warrant once the search is complete. You know, what's to end it? What's to stop it? Because traditionally what do police do? They knock on your door, say, we have a warrant, we want to search your house, take your stuff, go through it, and then give it back to you. All right? Or assuming they're not going to use it to prosecute you, they give it back. So if it's going to be a virtual search, then there's got to be a way to stop that, to prevent that, or to end that. So that's the big probably difference, I think, with the Trojan Horse warrant. But I think you're going to see more and more, excuse me, I think you're going to see more and more of these types of warrants. Okay, so that was the government using technology to go after folks. Now I want to talk just briefly about, can the government get access to your technology, all right? And so to do that, I want to start off with this case from California, Raleigh v. California. It involves smartphones. Okay, so here, this man was arrested after a traffic stop. Police take Riley's phone during the arrest and go through it. Based in part on the data stored in Riley's phone, the government charges Riley with an earlier shooting. Riley moves to suppress the evidence discovered on the phone. So historically, in this country, when you are arrested, the police can search you incident to that arrest, anything within the grasp of your arm. And they can go through your pockets. They can go through your black book. They can look at your beeper. Okay? They can look at matches, cigarettes, things like that. They can look at these types of things. Now the question became, can the government then look at a smartphone? And so half the country, surprisingly, Ohio here was cutting edge. Ohio said you can't go through the smartphone. It's unlike any other object you would find in someone's pocket. There's way too much information on a smartphone. If you want to search this smartphone upon arrest, you must get a separate warrant. Other portions of the country, surprisingly California, said no, you can look through someone's smartphone when you arrest them. As you can imagine, they can be truckloads of information. And then certain places said, well, maybe it only matters if you had your password, because if you had a password on a smartphone, that means you really cared about your privacy and you don't want people going through it. So the Supreme Court said, no, we're going to solve this. We're going to make a decision, and they did. 9-0. This is opinion written by Chief Justice Roberts, and he said that unlike other things you find in someone's pocket, the cell phone is both quantitative and qualitative different. There's a difference, all right? As we probably all seems very obvious to us. And he went on to talk about how the digital data stored in a cell phone cannot itself be used as a weapon to harm an arresting officer or to effectuate the arrestee's escape. And there's this big concern. They would say, well, you know that if you don't take the cell phone and search it, people will clean the cell phone remotely. And so the court would get into this argument that, you know, well, you just need to disable the cell phone, or you need to get the warrant faster. All these things. Bottom line is the Supreme Court is concerned about the ability to safeguard your information on your smartphone. And again, if you look in this, you're starting to see a trend here. The Supreme Court wants to give individuals more and more privacy rights, because I think we live a life so much online now. There's so much information about individuals that's available. You see sort of a pushback from the Supreme Court trying to take back some of the individuals' privacy rights. And you see this with these repeated cases. So again, the pendulum is swinging. It is swinging with respect to giving people more privacy rights, even if it sort of handcuffs, to, in a certain extent, law enforcement. Okay, now I want to talk about this case real quickly. So, like I said, the criminals are moving on to especially social media, and people go on social media and make all kind of incriminating statements. Criminals go on there, they plan criminal activity, they boast about criminal activity, they conduct criminal activity on social media. So there's a big, strong police presence on social media. The example of that question that was asked about the police even set up their own bogus Facebook accounts. So here we have an example this is probably one of the first cases, a 2012 case, of what type of Fourth Amendment protections that you may have on Facebook. Okay, so you have this guy, his name is Melvin Cologne. He, along with some other guys, they're involved in some RICO violations that involve drug activities. Cologne had a Facebook page which had certain levels of privacy settings. This Facebook page was not available to the public, all right? He had different levels of privacy. On one level, he had his friends. They could see certain things. On another level, he had information that only he could see, all right? The government wanted to see the information that he could see, all right, that Cologne could see. So the government had basically two choices. Go get a warrant or go become one of Cologne's Facebook friends. And I don't think they had enough for a warrant, none at the time. So they found one of Cologne's Facebook friends, friended that person, got to see that second level information. That second level information talked about criminal activity. He said, the police said, great, I'll use this. They took that information to the magistrate judge, received a warrant, and then went and looked at all the rest of his Facebook information. It was enough to convict him on these charges. And so Cologne went, then challenged his conviction. He did a motion to suppress. He argued that what the government did violated his Fourth Amendment rights. He said the government should have got a warrant immediately, not gone to his Facebook friend. Excuse me. And the court said that his expectation of privacy ended when he disseminated posts to his friends, because those friends were free to use the information however they wanted, including sharing it with the government. So when you go on social media and you share information with your friend, and that friend no longer is not really your friend, is really a friend of the government, there's nothing preventing the government from using that information. Now, the government cannot just get your Facebook information through Facebook. They have to go through a process, which I'll talk about briefly. But if you either friend the government or the government friends your friend and finds information, there's nothing unconstitutional about that. You give up your expectation of privacy when you share all this information with other people. It goes on to say, Cologne surrendered his expectation of privacy. The government did not violate the Fourth Amendment when it accessed Cologne's Facebook profile through a cooperating witness. Any questions on that type of process with respect to social media? I know some people question that a little bit.
I haven't seen any questions come through.
All right. Now, briefly, I want to talk about email. So can the government access your email? Here, this is not a Supreme Court case. This is a Sixth Circuit case. This is about, some of you might have been familiar with this, or at least in the commercials. This involves Smile and Bob. This was a mail supplement that was actually a sort of Ponzi scheme. Well, anyways, the government was going after one of Mr. Warshak here, and they wanted to get access to his email. And his emails ran through Nuvox Communications. And in order to get his email, the government used a subpoena to get his email. And so Mr. Warshak challenged that. He said the government's seizure of approximately 27,000 private emails constituted a violation of the Fourth Amendment. And the court agreed. They said, if you want to get those emails, you need a warrant. A subpoena is not going to be sufficient. And however, unfortunately for Mr. Warshak, there's an exception to the warrant requirement, the good faith exception. And here, the court said that the government relied in good faith on the Stored Communications Act, therefore the reversal is not warranted. However, the takeaway here, at least for those who are in the Sixth Circuit, Michigan, Ohio, Kentucky, I think that's all the folks, maybe Tennessee, I'm not sure, but those states in the Federal Circuit, you need a warrant to access someone's email, okay? And so the court goes on and talks about how you can't get this information just based on a subpoena, regardless of what the Stored Communications Act says. You have to have a warrant and probable cause. Now, briefly, just wanted to talk about the Stored Communications Act. So this is a statute back from the 1980s, way before they even thought of social media, and before, I don't even know if Mark Zuckerberg was alive then, but they passed this law to provide people increased protections with respect to using electronic communications. So bottom line, with the Stored Communications Act, if law enforcement wants to access your Facebook page, your LinkedIn account, your email, okay, they have to adhere to the Stored Communications Act. So if they want the content of the information, and it is less than 180 days, and also, I don't want to get in the nuts and bolts, but they make a distinction between ECS and RCS. They make a distinction between how the information is being used. But for the most part, if it's content information, okay, the nuts and bolts, what does the message say inside? They need a warrant to do that. Now, if they just want to know things like, oh, what time was it sent? Or who did you send it to? They don't need a warrant for that information, okay? Similarly, if they just want to find out who you called, all right, on a telephone, they don't need a warrant for that. They need a warrant to get the actual content of a phone conversation, but to see who you called, they can get that with a subpoena. So that's what the Stored Communications Act is about. It places limits on law enforcement and how they can access certain information, okay? The challenge, of course, is to find out what constitutes content. Some of it's obvious, the message itself is content, but is the subject line content, or emoticons content? How does it work with pictures? How does it work with metadata? So that's some of the challenges with respect to how do you define content in the Stored Communications Act and the with respect to the Stored Communications Act. All right, now I'm going to briefly just switch gears here now and move to the Fifth Amendment. Understand the Fifth Amendment protects you.
Thaddeus, can I jump in for a second?
Sure.
Real quick, before you jump over to that, we have a quick question that seems for us to grab now. Does a Trojan Horse warrant apply to a work computer?
Oh, I'm sorry. Yeah, the Trojan Horse warrant. Now, meaning as in, is this a government employee or a private employee?
Well, the question doesn't
say?
Doesn't give us that information, but I'm going to take it that it's a Trojan Horse warrant from law enforcement asking your employer, directed at your employer or your work computer. Does that make sense?
No, I'm with you. Yeah. No, they could use it with respect to either your work computer or your home computer. Now you have less rights with respect to. I mean, your rights are strongest at your house. All right, but you still would have certain Fourth Amendment rights with respect to your computer at work as well. But if they wanted to, they could do it to your work computer.
Okay, great. Thank you.
Mm-hmm. Okay, so with respect to the Fifth Amendment, as I stated earlier, the Fifth Amendment states that no person shall be compelled in any criminal case to be a witness against himself. So basically, you need two requirements for the Fifth Amendment to kick in. You have to have testimony and compulsion. All right. So the Fifth Amendment does not apply to information that you willingly give somebody. So it's forcing you to talk, as opposed to if you go on Facebook and make incriminating statements, well, having that turned over is not forcing you to, it's not compulsion. You voluntarily made those statements, all right? So the Fifth Amendment doesn't apply in those situations. It's in a situation where they're forcing you to talk, all right, or use some method of communication. When you've already created that information, that's not that's not compulsion, and that's not going to be protected by the Fifth Amendment. So how does the Fifth Amendment arise with respect to what we've been talking about today? Generally, when you see the Fifth Amendment rise is when the government issues somebody a subpoena to the criminal defendant, and in this context, it's usually with respect to a password. All right. So the problem happens, the government suspects you of something, or they've even indicted somebody. And what the information they want is generally, unfortunately, arises in child pornography. They want files, computer files, and they, for some reason, can't open these files because they're encrypted. And so, of course, it could be in other contexts of hacking, of cybercrime. And they ask you, say, I want you to open these files because we can't do it. We want that password. And the question becomes, is that a violation of your Fifth Amendment right when the government orders you, because that's what a subpoena is doing, is directing you to turn over this password information? And here's where, and the problem here is that the case law is not really clear because you have courts going in different directions, all right? So generally speaking, they can issue this subpoena to you, all right? And here's the exception, all right? The exception occurs when the very production of those documents proves ownership by the user, authenticity of the documents, or requires the user to engage in some mental processes to actually assemble or put together the information requested by the government. So I don't think that's the language, but I don't know how clear that is. So I want to try to summarize it briefly and then give you just two quick examples. All right. So if you're telling the government something it doesn't already know, you're testifying. If you're just giving the government something it already knows, you have and knows about, you're not testifying. You're not just handing over physical evidence. So basically, hopefully the case will explain, if the government already knows about it and where it exists and they just need the password for it, then you're probably not going to violate the Fifth Amendment. But if the government doesn't know those facts, then the government may be violating the Fifth Amendment, and they may not force you to testify. But again, these cases are fairly new and have not worked their way up the system. So some of the decisions are somewhat contradictory or sort of hard to distinguish between. So let's start off with the United States. These are the last two also. Let's start off with the United States v. Kirshner. All right, so you have the defendant here is indicted on 3 counts of child pornography. Subsequent to the indictment, the defendant received a grand jury subpoena that directed him to produce the password to encrypted files on his computer. Defendant moved to quash the subpoena, arguing that it violated the Fifth Amendment. The court agreed with the defendant, finding that requiring him to disclose the password would be compelling, incriminating testimony. According to the court, in the instant case, forcing the defendant to reveal the password for the computer communicates the factual assertion to the government, and thus is testimonial. It requires the defendant to communicate knowledge, unlike the production of a handwriting sample or voice exemplar. So here, you're actually communicating some kind of idea, concept, by giving the password. And so here, they thought that this stuff would be on the files, but they weren't sure. Now, keep this Kirshner case in mind and then look at the difference between this and Boucher. So here, in Boucher, the defendant was crossing the United States-Canada border when he was designated for secondary inspection. During the secondary search, a federal agent booted up Boucher's laptop and found 40,000 image files, some of which appeared to be pornographic. All right. When asked by the federal agent whether there was child pornography on the laptop, Boucher said he was unsure. All right. The agent then searched the Z drive and saw that he believed to be child pornography. The agent then shut down the laptop and arrested Boucher. Then they tried to do it themselves. They couldn't. They needed the password. And the government said the password was physical, not testimonial evidence. And initially, and then the defendant moved to quash. That's what you do when they send you the subpoena. You move to quash. And though at the magistrate level, the magistrate agreed with the defendant. They said compelling Boucher to enter the password forced him to produce evidence that could incriminate him. Entering a password into the computer implicitly communicates facts. By entering the password, Boucher would be disclosing that he knows the password and has control over Drive Z. All right. Now, the government appealed, and in the appeal, the district judge decided in favor of the government. And here, I think that one of the key issues is that the government knows of the existence and locations of the Z drive and its files. All right, so it seems a little less like a phishing expedition and more like, hey, you just can't have incriminating evidence that we know of and say, oh, because it's locked in an encrypted file, no one can get access to it. All right? That's not generally how it works. If you have stuff that's incriminating. The police are aware of it. You have to turn it over. Now, this obviously can be applied to different areas. So it'll be interesting to see how the rules shake out with respect to requiring someone to give up a password. And again, I think you're going to see more and more of these kind of cases because I think people are going to be more inclined to use encrypted files. Okay, so this basically ends my portion of the presentation.
Well, before we come back to me, we've got about 15 minutes left in the presentation. I want to ask Thaddeus one more question that came in from the audience. So Thaddeus, if you're still there.
Sure.
The question is, I have a question going back to cell phone searches. Most phones today have a feature where you can erase all the data on your phone from a remote location, normally used when the phone is lost or stolen. Does that possibility create an exigent circumstance or any other exception which will allow the police to search your phone before obtaining a warrant? I think what that question is asking is the possibility of you being able to erase that phone, does that give the police kind of an emergency situation where they need to look at that phone now rather than wait for a warrant?
No, that was that they raised that question actually in the Supreme Court opinion, and their answer, which I don't think was an adequate response, was that you can disable the phone. But at that point, when they wrote that, either it was already available or it was only a matter of time before you get to a point where where anyone can erase what they have on their computer. Anyone can erase with their phone at the drop of a hat, or they can do it remotely. And that was one of the big issues of the exigent circumstances. Now, again, I think you could always raise that. If you're law enforcement could raise that. I think, though, that you would have to have some compelling, to get over that hurdle, you'd have to have some compelling exigent circumstances if you're going to try to get over that hurdle, because I think they considered that when they wrote the United States v. Jones decision, and I think that's one of the sacrifices they were willing to make in order to safeguard someone's smartphone, because really you're carrying so much. I guess the problem you have is, for example, look at that example. I forget what Riley was doing. She was shooting. Was it a shooting? But let's say you have someone who's selling drugs. What is the likelihood that when you arrest that person who's selling drugs, that they're going to have the phone numbers of people who are buying drugs and selling drugs with them in that smartphone? And that once they find out this guy's arrested, they're going to erase all their information. I mean, I think it's a high likelihood. I think there's a strong chance that that's going to happen. But I think the court took that in consideration when they came out and decided, hey, you need a warrant to arrest this person. Again, as well, this is one thing, one response could be is absent you arresting someone on the spot, which does happen. Most people have warrants. The police can get a warrant also to search a cell phone when they arrest you. For example, I have a smartphone, so they're going to arrest me and say, Thaddeus Hoffman, we have a arrest warrant. We also have a search warrant for your phone. They could bring both of those type of warrants to arrest. Now, it makes it more challenging when they make on-the-spot arrests, of course, because they may not have a warrant in hand. But I think you'd have, if you wanted to get, an exigent circumstance is an exception to the warrant requirement, but I think you'd want to have some very strong circumstances if you wanted to rely on that, because I think the court took that in consideration when they made the Jones decision.
Okay, great. Thank you.
Riley. I'm sorry, I said Jones. I meant Riley v. California.
Okay. Okay, we have just about 15 minutes left, a little less than that. We wanted to end today's presentation by talking a little bit about loss prevention, and we're going to talk a little bit about insurance, too, real quickly. So with that, from a loss prevention standpoint, as an underwriter of security and privacy insurance products, and seeing a lot of losses that happen due to failures of computer security, there are 4 things that I want to recommend that companies should key in on to help prevent losses from happening. The first, from my standpoint, is employee awareness training. Having employees that are aware of the type of things that we're talking about, be careful about clicking on links in emails, be careful about things that look suspicious, be careful about downloading things from the internet. can go a long way to preventing a failure of computer security. Second would be periodic testing of computer security. Computer security isn't a static defense. It really needs to be dynamic. And the best way to make sure that your computer security is doing what you think it is to periodically test it. And on that point, it's worth noting that the same tools that are used to be able to test your computer security, doing things like vulnerability scans and penetration testing, those tools are also available to hackers. So they can just as easily scan your network and get an idea of where your vulnerabilities are. So it's a really good idea to check and make sure that you know where your vulnerabilities are and be able to make corrections before they can take advantage of those things. And right along with that is patch management. Mostly when you test your computer security, what you find out is you learn what patches or software updates that you've neglected to install. The prompt installation of software patches, updated computer security software updates, can really help prevent problems. And the last one from my point of view is encryption. Now, encryption is great wherever you can implement it, but I think it's most important on portable devices, things like smartphones, laptops, USB drives, because when those things get lost, you're very likely going to have a notification obligation, if not a worse situation, if the data stored on those devices is not encrypted. So with that, from my standpoint, I think we have some things that we're going to ask Juliet to talk a moment about business process controls that can help prevent things from the crime side of the house. So Juliet, could you talk to us a little bit about that?
Sure. So I think just some general areas surrounding good basic due diligence procedures across all organizations are having proper checks and balances in place. So an example might be with payroll, having one person designated to set a new employee up in the system, and while another person verifies that that person is in fact who they say they are and confirms with their new manager that that was the appropriate hire and that all of their banking information is correct. Again, just having proper checks and balances in place to avoid any fictitious employees being entered into the system sounds very basic. You'd be surprised how many fictitious employees there have been in a lot of our insureds. Another example of that would be having proper funds transfer threshold approval processes in place. So ensuring that I can't approve and initiate a wire transfer request over a certain dollar amount. Maybe it's $10,000, and then if it's over $10,000, I have to go to my manager and get approval. And then if it exceeds their authority, then they have to go get approval. So again, just having those proper procedures in place to kind of stop and check and make sure that we in fact do want to send that money to wherever it's going. Another issue that we see a lot is vendor management, and we see quite a few claims surrounding fictitious vendors or employees in collusion with vendors that have been created in the system under family members' names. So really doing your due diligence on the vendors is very key to preventing money from traveling outside of the organization in an incorrect way. Whether that is, performing background checks, making sure that addresses and contact information is accurate, cross-referencing employee lists with the owners of the vendors whom you're contracting with, and if something looks funny, looking into it. We've seen lots of incidents, like I said before, where an employee will set up a vendor that is in fact their mother, and they're, writing them checks every week for $2,500. Well, it doesn't sound like a lot, but it adds up over time. And then lastly, I would say employee training. A lot of organizations have really great internal audit departments, but you'd be surprised at the lack of identification that those internal audit departments actually find in terms of crime losses. It's generally someone goes on vacation and someone notices that, oh, this payment's getting made to, Mr. Smith. This seems odd. What is this? And that's how we uncover a lot of losses in our space. So I would say those are some of the key things to recommend to your clients, and I'm happy to take any questions on that.
Okay, let's spend a moment real quick just talking about insurance and kind of differentiating between crime insurance and cyber insurance, and then we'll take a moment to address some questions. From the crime insurance standpoint, I understand that that's really going to cover things from theft of funds issues, fraudulent transfer of funds, either an internal party, an employee fraudulently transferring the money to their account, or a third party doing that. Is that correct, Juliet? Could you expand on that a little bit?
Sure. So the crime insurance policy is really meant to predominantly pick up employee dishonesty. That's how the coverage was created when it was first drafted in the 80s. And it's really bonding your employees to the organization. So when they are dishonest, that's what this policy is meant to pick up. It's obviously evolved over time, but it's still fundamentally only meant to address theft of funds and assets that the insured has, not data assets, strictly speaking, money, securities, property. And I think that that's a very important clarification to make, because with the majority of claims coming in that we see, there tends to be an overlap and a confusion surrounding data versus funds and where the claim really lies.
Yeah, that's a great point, because the cyber insurance, which I like to call security and privacy liability insurance, is really designed around the data. And so that insurance would really respond to legal liability arising from a theft of payment card information from the entity, as well as any breach response costs, things like computer forensic services, legal services, public relations services, offering credit monitoring, or computer forensics, if I didn't mention that, are all things that we would lump into breach response costs. So if there was a failure of computer security that led to some type of theft of information, including payment card information, that's really the purview of the cyber insurance policy. And then last, we have under the not covered section, and Juliet, I'll ask you if you have any comments here, would really be the fraudulent instruction claims, unless the policy is somehow endorsed, would not normally be covered under each policy. And that's the claim where the insured's employee is tricked into transferring funds to a criminal third party by some sort of fraudulent email or something that pretends to be from the CEO and says, please make a quick transfer to this company and this foreign land of $1 million. That's largely not covered today. Correct, Juliet?
Yeah, that's correct. And we even see instances, and there's specific exclusions in the majority of crime policies in the marketplace today that even exclude the fraudulent or willingly giving away your goods. So it's not even funds. It's also, your widgets. If you're a widget manufacturer and someone asks you to send them, 1 million widgets, and you just do it without doing any due diligence, that's really not something that the crime policy is meant to pick up. And it's the same, vein for funds. So if someone emails you and says, wire me all your money, and you do it, unfortunately that's not a covered claim at this time.
So I think we refer to that as a voluntary parting of the information.
Correct.
With that, I think Matt had some final comments on things that he was going to recommend from a loss prevention standpoint. So Matt, can you talk to us about protective strategies real quick?
Yeah. So so what do you do? I mean, we've kind of just heard of the last hour or so, all the things that could go wrong. So how do you prevent things from going wrong? And it all comes down to what are you protecting. So, each company needs to look at the assets that they're looking to protect. Know what they are. Know what regulatory requirements you may have around that business or that data that you're protecting, and make sure you have good process around that data and those assets. And then evaluate the risks and threats that you may see. If it's, as Juliet said, if your widgets are important, you need to make sure that you have the right controls around them to make sure that they're only being sent out by authorized manners, whether it's funds and other controls. Make sure you understand those risks and threats against that. And then just look for common, I call them best practice controls that are in place. So different industries tend to have information sharing forums as far as how are your competitors or customers doing with respect to protecting some of their assets. So you just need to kind of some basic stuff as far as identify what you want to protect and then determine how best to protect it based on the threats and risks around it. So, start off with really basic controls. It really depends on each industry. I think we talked about some of these already, strong passwords. Nick already mentioned, mobile and laptop devices, make sure they're encrypted and password protected. Employee awareness is always very strong. It's sometimes you have to find the weakest link, and unfortunately that weakest link is sometimes just employees and human nature. Middle of the night, I got an email, I got to respond, it's my boss's boss. Maybe I need to think before I actually do something or say something or send something off.
All right, thank you, Matt. I really think you had a great point there with physical protection of things. It wasn't one of my 4 things, but we've certainly seen some significant losses of computer data resulting from the theft of computer hardware, things like servers and hard drives that you wouldn't expect just to go walking out of an organization. But, we have one particular large loss arise from the theft of 4 obsolete desktop computers. But unfortunately, those desktop computers hadn't been wiped of the information, so when they were stolen, and it was almost not noticed because they had been rendered obsolete, when they were stolen, the information went with it and created a big problem. So I think we got through most of the questions that we received this afternoon. I apologize to anybody whose questions that we didn't get to, but we have run out of time now. So at this point, I'm going to pass it back to Kathleen, who has some final comments for us.
Thank you very much. And as Nick mentioned, if there are questions that did not get answered today, our speakers encourage you to contact them directly using the contact information on the last slide in today's deck. We would encourage our attendees to please complete the survey that will appear for you at the end of the webinar. Your responses help us craft excellent CLE programs that meet your needs. Thank you all, and have a great day.